Now, each party should present an opening statement outlining their position, key argument, and the relief sought. Do you understand? If you are asking for an award, you should tell us what you are asking for. So all of this I know. So this set the stage for the evidence presentation. You understand? So once you make your argument, then and everybody make submit and make an argument, at the end of the day, it's make create room for evidence. You understand? So talk about closing statement, closing statement. Summarization is key here. After all evidence have been presented, each party provides a closing statement summarizing their case, reinforcing key arguments and addressing any weaknesses in the opposing party's case. Do you understand? So you must uh, give a summarizing statement. At the end of the day, for us, this is what we are looking at. This is what we're looking at. So we're looking at. Very important. Then we talk about post hearing submission. Post what? Hearing submission. Post hearing submission. Written summaries. Written what summaries? All right. In some cases, parties may be asked to submit written summaries of their argument or additional evidence after the hearing. This can help arbitrators in their deliberations. So, even after a case must be heard and examined, you can still submit evidence if you think the evidence is strong enough to support whatever argument you have offered. Do you understand? So it's important. Deliberation and award. So deliberation after the hearing, the arbitrators will deliberate privately to discuss the evidence and argument presented. So then after they are satisfied with whatever argument, they will pronounce an award. Do you understand? Issuance of award. The arbitrators will issue a written award detailing their decisions, reasoning, and any orders. Okay, based on this fact, based on whatever they say, and based on this the decision of the arbitrator. So this award is typically binding, meaning it can be enforced in a court of law. Do you understand? It can be enforced in a court of law. Then let's look at the issue of confidentiality. Private proceedings, right? Arbitration hearings are generally private and the details are not publicly disclosed, contributing to confidentiality, except where there are issues of life threats that you can decide to review. Otherwise, it is totally a secret procedure, private procedure. You understand? So that's what it means. So, but let's talk more on some of these aspects that we have discussed here. We'll be looking at the presentation of evidence, how evidence are being presented. We'll look at the examination of witnesses, and then we'll look at the submission of arguments. Do you understand? So I want us to look deep into some of these aspects of arbitration before we call it a day. So evidence presentation. So what kind of evidence are you bringing? So types of evidence must be considered. Parties can present various forms of evidence, all right, including documents, expert reports, and physical evidence. So whatever evidence that is at your disposal to be able to share, you can share them. Do you understand? You can share them, and then you can be able to submit it as an evidence to consider. Then submission of evidence. So evidence is typically submitted in advance. You are not going to submit in the process. That is during the pre-conference or pre-hearing conference. That is when you are expected to submit your evidence. Do you understand? In advance before the proceedings start. So advance of the hearing, often in the form of witness statement or expert reports. This allows the tribunal to familiarize itself with the materials beforehand. You understand? So rules of evidence. Unlike court proceedings, arbitration often follows more flexible rules regarding the admissibility of evidence. So allowing for a broader range of materials to be considered. So as many materials that are at your disposal that you want to share as evidence to support your argument, you are allowed to bring them. Do you understand? You are allowed to bring them. So that's about the presentation of evidence. So what do we say? We say that the types of evidence matters, the submission of the evidence, and the rules of the evidence matters. Then let's look at the witness examination. Witness examination. We'll talk about direct examination. The party who calls the witness conducts the direct examination, allowing the witness to present their testimony and evidence. Do you understand? So that's what we call direct what examination. So the party who called the witness conduct a direct examination, so allowing the witness to present their testimony and evidence. So that's what it means. And then we'll talk about cross-examination. Cross-examination, the opposing party has the opportunity to cross-examine the witness. Do you understand? Challenging their credibility and the facts presented. So if you examine someone may try to oppose and also criticize your argument and your decision and the evidence presented. Just like in the court, cross-examination, do you understand? Then you have what we call re-examination, direct examination, cross-examination, re-examination. Take note of this. If I ask you in the exam, you will not be confused. All right? So re-examination. After cross-examination, the original party may conduct a re-examination to clarify any point or address issues raised during cross-examination. So person who open the conversation through direct examination can, have the opportunity to re-examine the person or the issue. Then the last thing that we're going to consider here now is the submissions. All right. So opening statements. Each party typically present an opening statement outlining their case, the evidence they will present, and the desired outcomes. So you are telling the arbitrators what you are expecting at the end of the process in your opening statement. All right. Talk about closing argument. So after the evidence has been presented and witnesses have been examined, parties make closing arguments, summarizing their position and the evidence. All right. So at the end of the day, this is what we say, and this is our evidence. All right. So this is our evidence to support our argument. Do you understand? So these are the issue. All right. Mm-hmm. So written submissions. In some cases, parties may also provide written submissions to the tribunal, either during or after the hearing, to reinforce their argument. So in case there's a need for you to put it in written, you go ahead and do it. Let's look at some additional consideration when it comes to submissions or comes to this issue of arbitration. Talk about confidentiality. Arbitration hearings are generally private, and the confidentiality of the proceeding and evidence is usually emphasized. Tribunal's role. The arbitrators have the authority to manage the proceedings, including the admission of evidence and the conduct of examinations. So they may ask questions and seek clarification during witness testimonies. Do you understand? So this is what this is the job of the this is what the role of tribunal is. But I'm telling you that arbitrator has the power to admit and cross-examine evidence. Do you understand? Procedural rules. The specific procedures for hearings can vary based on what the arbitration rules choosing. It can be ICC, it can be LCIA, that's London Court of International Arbitration. We talk about the UN, the UCITRA, that is the United Nations Commissions on what International Trade trade law, okay, and any other agreements made by the parties can be considered. Do you understand? So this is what we cover in this course today. Tomorrow we are going to look at the arbitration rules and procedures. So we are considering AA, ICC, UCITRA. We can also consider maybe ACA, for instance. Now that is ACA. Do you understand? So just make yourself available so that you know what the act says. Do you understand? Which will help you to get more knowledge. All right. So, and before we finish this module, we'll be looking at the international arbitration. All right. The role of international institution in arbitration. That is, we're looking at ICC. Do you understand? Very important. Then we'll look at recognition and enforcement of international arbitration awards. So make your time not to miss any of these modules, these units that are remaining for this module. So thank you very much. We appreciate you and your participation. All right. So we are going to meet on Thursday. We will not be having training tomorrow, but this training will be rebroadcast by tomorrow evening. So if you miss it or want to listen to it again, you listen to it by tomorrow evening. All right. But tomorrow we're not going to have a live training like this, and we'll have it on Thursday, Friday, Saturday, and Sunday. So make time to be available for this training. Thank you very much. We appreciate you. We appreciate your participation in today's training. Any question? Somebody saying questions. What is the question? Ethan, what is the question? You say you have a question. Eniola, I thought you have a question. I'm trying to look at the question. If you have a question, just go ahead and ask straight. Don't say question. If you say question, you're wasting time. Just ask your question and then we'll attend to it. Right? So I didn't see your question anyway, but if I see it, I will address the question. So those of you that did not pass your examination, the emotional intelligence examination, you have 10 days or 10 to 15 days to go and read your book again, listen to the videos, and watch them again. So we'll have another examination for you. We'll announce the date, but just start reading. I will post it in our group on emotional intelligence so that you can get the details. But by all means, try and be part of. Just try and read. If you did not pass your emotional intelligence exam, just go and read your books again. Listen to the videos again. We'll conduct a second exam for you, and let's see how you perform in that examination. So thank you very much. See you on Thursday. Have a wonderful night rest.